Today we are very lucky to have Yvonne, Segars, and Mike Loeffler speak with us about the role of defense counsel in drug courts, and they're going to highlight two challenging cases. And this is a really unique webinar in the sense that we have two perspectives. Yvonne is a former public defender, and Mike Loeffler is currently an assistant district attorney with the Creek County DA's office in Bristol, Oklahoma. And just a little bit more background, Ms. Segars is currently a professor at Keene University with the School of Criminal Justice and Public Affairs and Public Administration. Prior to becoming a professor, she served as New Jersey's state public defender. She's a pioneer in the drug court movement. She's lectured locally, nationally, internationally on drug courts and other policies related to criminal justice and drug treatment. She's a former member of the board of directors to the National Legal Aid and Defender Association, as well as a former member of the board of directors to the National Association of Drug Court Professionals, where she also served as a core faculty member for the Justice Management Institute and as a fellow for the National Drug Court Institute. Mr. Loeffler is an assistant DA with the Creek County DA's office in Oklahoma. He's also the municipal judge for the town of Kellyville, Oklahoma. He is employed part-time as well as an adjunct faculty at the University of Tulsa, where he teaches contract law and introduction to law. He's recently completed 3 years of service as chairman of the Adult Committee of the Board of Directors of the National Association of Drug Court Professionals. He also serves on the steering committee of the National Center for DWI Courts and is also a fellow for the National Drug Court Institute. So with that, I will turn it over to Yvonne and Mike. Thank you so much.
Good afternoon, everyone, and thank you for having us. It's a pleasure to join you again, and I'm glad to be on the panel with Mike, Your Honor, I should say. Thank you for joining us also. We had our last webinar a few weeks ago was very interesting, and one of the things that came out of it were lots of questions from those who were on the call and those who we received communications from. So we wanted to kind of shift the focus to really try to talk about some of the challenging issues that we are facing in the drug court, treatment court, problem-solving court environment. We decided on, we asked the field for questions, we got some feedback, and we ended up with two kind of cornerstone cases that may seem very extreme on one hand, but they're also very complex and complicated as defense counsel in terms of what we need to do to help our clients succeed. And the first case is, and you will see the slides on your screens, and so feel free to ask questions as you go along. I should preface this by saying, in the field and the people on the call, I'm talking about those of you, the other participants, many of you have as much experience as myself or Mike, and so we appreciate your feedback, your input, your input, and we look forward to that. So please use the tools on the screen to ask a question or even submit a response or comment during the call, because that will be helpful to the field. So we're going to look at this first issue, and we've given the background of case one, which is an African-American female, and we're going to give you a stat. 27-year-old, single mom, 2 kids, ages 4 and 7, currently unemployed. 2 prior convictions for burglary and possession of CDS. That's why she's in drug court and in the treatment community. She has two cases pending: fraud and receiving stolen property, which if she went to trial and pled guilty, she'd probably end up in a state court of some or maybe county court. But certainly she probably would not still remain on the street with the priors that she has behind her. So what are the challenges she has? So this particular client, as you can see, progressing slowly. Most of the complaints are related to, quote, attitude, and those of you in court understand that a person who's not motivated, has some attitude. Recently failed breathalyzer for alcohol. Counselor believes that she's being fake by wearing a hair weave. By the way, folks, this is actually from a true case. and refusing to complete her workbook. And for those, if there's anybody on the call who doesn't know what a hair weave is, but that's, you know, fake extension hair that people sew into their natural hair. She is behind in her fines, but she has fancy fingernails, not finding legitimate employment, although she braids hair in her home to make money, basically under the table, but she can't seem to find full-time employment. Part of it is because of her children, and she's unable to get childcare, and she finds it difficult to keep up with the demands of her children, the program, especially since she doesn't have a car, and public transportation is very limited. So currently, she's missed a couple of meetings, group meetings. The participant has stated that she's failed to attend meetings because it just got too hard. She can't mentally do it. She can't physically do it. She went on further to explain that it got harder and harder, especially when they kept pushing her to talk about talking about her life in group. Said she thought it would be easier just to get an ankle bracelet. In her mind, she thought, well, I'll just get an ankle bracelet. She thought that because of the violation was only alcohol, not drugs, not anything illegal, and missing group meetings, that the maximum penalty would be house arrest rather than jail. She understood that she would be sentenced to house arrest or something to that effect. So she had some different level of expectation. So what do we do? So some of the concerns that were raised were things such as defense counsel suspects at the minimum that there may be some cultural insensitivity and possibly bias. Drug court uses only one treatment provider. Drug court is small, there's very little diversity, and the staff and the judge have been in place for several years, and no staff changes are expected. So these are some of the concerns, and I'd like to talk about them a little bit before we go on to the next slide. So the concerns, let me just talk a little bit about them one at a time. Particularly, we see in the field many cases where cultural insensitivity or even bias might be present. And how do you address that, especially if the clients feel that that is an issue? And one, how do you identify it? How do you know it's happening? How do you know it's an issue? And if it is, how do you address it? And if it's happening and you don't know that it's happening, what should you do? In this particular case, the woman was accused of wearing fake hair, not being herself, and basically because of that, she was masking over who she really was, and she wasn't coming to terms with who she is in her, and as far as it reflects related to her addiction. I know that wasn't very artful, but if you have any questions, I can try to explain that too. And maybe that comes from, in this particular case, because I talked to the person involved, that maybe it was because the treatment provider comes from the old TC approach, where you kind of have to bear people down to the the base of who they are in order to get to the reality of what the problem is, and or whether or not how she dressed or what she did and who she was with associated with the old way, the old lifestyle, and therefore she's not coming clean with herself and still living in her addiction and in the world of addiction. But how does that really show up when you ask somebody to take their hairstyle out, not wear braids, get rid of the dreadlocks, cut off your hair, go to a crew cut? I mean, it can go across a span of things. The drug court uses only one treatment provider. So, of course, there's not really, and one treatment provider is not unusual. There's lots and lots of courts that rely only on one treatment provider. And what do you do when there's no other alternative and there's no other counselor to utilize, and there aren't many options? What does one do where you have a client like this who is not phasing up? She's not violating the law. She's not doing anything, quote, illegal. But, of course, she's not totally in compliance either. And how far do people need to go to succeed, to get out of course? We do have so many standards that we want them to meet, but what do you do when you have this person who isn't really she's not really getting up there, but for reasons that may be related to cultural dynamics. And when I say culture, I don't just mean race and ethnicity. I'm talking about the culture of poverty. I'm talking about religious culture. And it might be, of course, ethnic and racial culture as well, but there are other aspects of culture, and we're going to, there's a list of them we can show you in a minute. And also the last item here is the staff and the judge have been in place for several years, and there's no staffing changes that are expected. And that may point to the cultural proficiency or the cultural competency of the team. You can have a very culturally proficient team, and then you don't have to be of the same race or ethnicity to be culturally proficient. And I don't think that people expect that. But I think that we do expect in the field, and counsel needs to at least appreciate that there might be some cultural bias that is taking place, and to at least identify it and to see what can you do to see if, to identify if there is bias, and if so, how do we keep that from having a negative impact on your client. Very often, people associate culture with race and ethnicity, and the issue is, well, if this person is Black or African American and nobody on the team is Black or African American, you have a problem. Well, you don't always have a problem. Sometimes you might have a problem, but you can have perfectly culturally proficient teams of the opposite, of a different race. So let's go on to the next slide. So these are some of the concerns, and this is not atypical. So client hasn't progressed through the phases, somebody who's just not moving along, stuck in a phase, or not phasing up quickly enough, maybe been in a program where other people have gone to phase 2 or phase 3, this person just can't seem to go forward. And not the kind of person you really want to put in prison if they haven't really done anything to break the law, but at the same time, we all know that the people have to comply with the terms of probation or the terms of the program, and staying in the treatment program and going to group and finishing your workbook, or all those kinds of things. And what happens with that one kind of person that's not succeeding? Not meeting the milestones, hasn't committed any other crimes, and the client is headed for state prison, because in this case, it would have been a third felony. And children are likely to end up as wards of the state, which is also very possible for a single parent who's not married and doesn't have any support system around her. If she, in fact, gets sent off to prison or to jail, her kids have to go somewhere. And very often that is in the, as a ward of the state, or with another family member, or in foster care, something to that effect. So what should we do? So in this particular case, we are talking about culture, and as I said, I hope that culture is taken as a very broad topic area that isn't just related to ethnicity or race, but certainly that is one of the main areas of culture that happens to have an impact on whether people succeed or don't succeed in the treatment courts. And where we have groups of people, in particular a specific ethnic group that isn't failing in the group, and we do know that African American males tend to fall out of the programs in greater degrees or percentages. In some communities, we'd like to know why that is, and if culture and ethnicity and bias haven't been looked at, and if we're not culturally proficient as team members, how can we at least have our own self-check? Because we have an obligation to look at our courts and look at ourselves and see if that's going on. This could be the culture, whether it's gender, LGBT. We've seen recently, this is much more prevalent now, that we're bringing attention to this community, and how do we not discriminate and not have bias where it comes to that community, whether it's in treatment, whether it's in groups, whether it's in who goes into the bathroom to watch a person observed, a person, with a UA. And there are a lot of, issues that we have to contend with regard to spirituality and religion. We've seen this even to the extent that a probation officer who visits a person, a Muslim woman, or somebody of a particular faith, if you're in the wrong, you can't visit certain people's homes if the husband, if they happen to be married, is not home. If they're of the opposite sex, it's against their religious values. the culture of poverty. I talk a lot about the socioeconomic disparity because there are very often issues and milestones that our clients are expected to meet that are hindrances simply because of economics. Whether you can afford transportation, whether or not you have a car and you can get to here, get to group, or get back and forth to where you belong, or you don't have bus money, are you not working? And those socioeconomic disparities have to do with whether or not you're even employed. And we all know how much more difficult it is for our clients who might be less educated, who more likely have and our clients, of course, for the most part, or they wouldn't be in these particular courts, have a prior record. Having a prior record knocks you out of the box from the beginning just in terms of getting employment and competing for jobs. Not being able to be employed, and most of our programs expect our clients to get a job. They expect them to become employed, or they don't meet that milestone. Education, and I've seen a lot of programs now are beginning to, or at least some, have taken the mandated get your GED or you can't get out the program a little off the table. But that was, in many programs, that's still the case. They want them to either get a GED or to make sure they have a job. What other kinds? Oh, the issues of physical proximity. We say look into the eyes. That is a kind of a short for, there are aspects of our cultural communities where if you, and this is the example, if you look someone into their eyes directly, what does that signify? Is it a sign of respect or a sign of disrespect? If you speak to your probation officer and you cast your eyes down, does that mean you're hiding something, or does that mean that you're avoiding, or does that mean that you're showing respect? Well, depending on who you are and where your culture comes from, any of you on this call, you would probably give different answers. If I cast my eyes down, what does that mean to you? I'd like some of you to type in your responses. I'd like to know. But for many communities, it is a sign of respect. But for other communities, it's a sign of you're hiding something. And those kinds of disconnects shape how we view these individuals, how we treat these individuals, whether we believe them for what they're saying, and then how that affects their status as they go through the program. So this kind of example we use to say we have to be very careful to make sure that we're being as culturally proficient as possible, and also as attorneys who have counseled our clients in this criminal courtroom where there's no other criminality taking place. How do we ensure and protect them to see and to shepherd them to see that they come out of drug court at the same time knowing that they may not be in full compliance for a variety of reasons that we really don't have the control over, nor are we going to fix these people during the time period that they are going to be in the court. This is the definition from the U.S. Department of Health and Human Services. When we're talking about cultural competence, it refers to that ability to honor and respect the beliefs, languages, interpersonal styles, and behaviors of individuals and families receiving services, as well as the staff members who are providing those services. We very often look at those people in the group, the people in the program, and we want to look at them, and we don't really look at ourselves to understand how much our own perspective may have an impact on the outcome. It is not always just the individual. When the individual in this particular case, as I said earlier, to start a call, this was a real case where the treatment person wanted the woman to remove the hair weave because he felt that she wasn't being true to herself and that she was faking it and that she had long fingernails, so therefore how come she couldn't pay her fines? If you can see how that got into the mix and it became a very complicated situation. By the way, she did not make it out. She was terminated, and she spent a year in jail. But when we talk about interpersonal styles. I mean, I think that falls into that category. But that was a situation that I felt was really about cultural incompetence. So I don't know, Mike, do you want to jump in here before I go into the next slide? Do I see Michael? I don't see Michael. Okay, so I'm going to continue on. It looks like he might have dropped off the call. I can't see him. Okay, I'm going to continue on. So in this particular instance, what we call a tough case, and it's tough for us because, not because the person did anything really bad, or, you know, even though she did have breathalyzer failure, but in her mind, this particular client, it was alcohol. Alcohol is legal, but of course we know that we can't have alcohol or any kind of toxic, any kind of, you know, anything that like alcohol as well, but still it's not illegal. And so how do we protect our clients when they are falling short of things outside of alcohol, like not paying fines and penalties, not, you know, filling out their workbooks, and really not becoming, not really being the kind of, not gaining complete recovery, which is where they're falling short. They're not in recovery completely to the extent that we want them to achieve, but that makes it very challenging for defense counsel to keep them above water so that they hopefully will finish the program and not be sent to prison. Providing culturally competent services, the question really becomes, is your court providing equal access and equal opportunity for all participants? And really that requires an analysis of your own court to identify and analyze those issues that may show up as some inequality. Have you taken the opportunity to examine the court that you're participating in terms of who is eligible for the program, who is not? If there are people of different ethnic and racial backgrounds in the court, have you really, has your assessment has your treatment provider or whoever does your assessments, are they utilizing assessment tools that are targeted for historically disadvantaged groups? Have you really factored that in so that you can get the kind of information from your clients in the beginning to ensure that you are having culturally proficient assessments? And it's not just the tool, it's how the tool is actually given. How is the tool actually, you know, forgetting the word, but I'll think of it. You should be looking at your own statistics within your court. Now, in some jurisdictions, I've heard, and I go to different parts of the country, they say, well, you know, pretty much we don't have anybody of color in our courts, or there's no other ethnic communities pretty much. That doesn't mean that there still aren't cultural deficiencies related to other aspects, whether it's gender, poverty, economic, education. You know, those are still culture, spiritual, religion, and just how you live. Those are still cultural biases that you have to take stock of. I mean, we can all be of the same, it could be of the same ethnic race, ethnic community. It doesn't mean that you don't have cultural biases built in. How do you train your children? How do you discipline your family? How do you know, what kind of, you know, what do you consider an acceptable family unit? All of those factors tend to color how we perceive people, how we treat people, and how we then judge. And really, it's hard not to judge, but whether or not they deserve to be pushed ahead to the next phase, or if they're succeeding. Criteria for sanctions and criteria for terminations. And I think although we write things down in our booklets, and when people join drug court or accepted into drug courts, the question really becomes, are we very clear about what behavior makes somebody eligible for a sanction or not, and making that clear and communicating that. Mike, I see you're back. Are you with us?
Yes, I am. Can you hear me?
Oh yeah, I know. I called for you and you weren't there, and I was like, oh no, Michael.
We're having a thunderstorm in Oklahoma, and that messes with the electronics. I apologize.
No tornado, I hope not.
No tornado.
I don't know how much you heard of our comments when you dropped off, but I didn't know if you wanted to add anything. And you and I talked about this topic already, about this particular case, and also.
The only thing I might add, and this is arguable, people can argue with me, but and this is not necessarily in the same category as historically disadvantaged groups. You know, but leading into my fact scenario, which will be later, is that we need to be aware that there's also a culture of addiction, and it is not homogeneous by any means either. And so if you're trying to change behaviors, and those are some of the behaviors you're trying to change, you need to be aware of how well those are ingrained. I just saw a question from Marty that talked about how cultural norms can be changed by living somewhere else, and people's cultures can be changed by addiction too. I think we need to be aware of that.
That's true, and also the drug culture, right? The drug culture
itself.
We
call it that. We call it the drug culture. So.
And once we're how we exist in that other world, and then some of those habits, behaviors come with us or come with them to their day-to-day. I'm looking at a comment from one of the, if I might, one of the participants on the call who actually, I don't know if everybody else can see this or if I can just say it. I'll just say it, where her colleague had gone to the Middle East, and while they were having lunch, I'm assuming she was female, but the woman would not look at the husband of this woman who's writing. She wouldn't look him in the eyes.
Well.
Say that again?
That's the one I was just referencing, yes.
Right.
Absolutely. That was a good comment.
Yeah. Okay, let's go into our next. So how do we provide we want to provide these culturally competent services. And we have to, commit to providing those competent services for all participants. Sometimes we need to have gender-specific treatment groups. Now, not all treatment courts have gender-specific groups. I have seen it where we had to move a woman. I had a woman in a female group who it was a very complicated situation, and because she dressed as a male and they didn't want her in the group, and we had to, it was really quite complicated because they didn't know how to engage this woman who was identifying as a man, and they would not remove her from the group, and she eventually did not make it out of drug court. But I actually believe that it was probably the lack of skill that our court didn't have with how to deal with this transgender person. So I think that it's important that as we look at these issues, if we identify that people are not progressing and they're not motivated or they're struggling in group, but that we have to really take a really close look at why they're not. And this is about that individualized treatment. We've said many, many times that on one hand, we want people to not feel that one person gets a different treatment than another, but at the same time, you have to have individualized treatment services to deal with the individual issues that people are facing. But at the same time, which of course will explain why one person gets an ankle bracelet and another person gets a weekend in jail. That also seems to, for many people, not to be fair, but we don't really know what those individualized issues are.
Can I ask you a broader question in regard to that, just for discussion? Because gender is one aspect of where you can have specific treatment groups. But as I'm sure you're aware, and the participants are aware, there are others. For example, I have the ability to refer members of the predominant local Native American tribe to specific treatment for them, and sometimes they don't want to go. And I'm using something specific to my court being in Oklahoma, but you could substitute veterans, you could substitute gender as you have, you could substitute race and ethnicity and language, any of those. So if I'm a member of a tribe and I'm referred to that, what do I do? What do you do as counsel when they say I don't want to go to that? I may identify with my tribe, but I don't want to go to treatment there.
Well, I think that is my view is that if your client is succeeding with the program that they're in, why should we, if it's working for them and they're doing well and that's where they feel comfortable, why should we interfere with that? I wouldn't force anyone to participate in any group if they were succeeding in their program. I
agree with you. But you see, my point is that we don't particularly want a forced I don't know what you call it, a separatism upon people if they don't want it as well. Do you agree with that?
Oh, absolutely. Oh, absolutely. Right. But then let's flip it the other way. If you had a Native American who wanted to be in a wellness program, which is a little different than what we would call wellness, and in their culture what they respect as that, and we don't have it, then we're not serving them, correct? Then what do we do?
I agree. Yeah, that's a different situation. That's the flip side, and I agree with you.
And the flip side of that
100%.
is that I think that we have to figure out ways to go into the community and identify ways to help address that one person, even if it's that one Native American who's struggling, who's not in culturally, aligned, and things aren't working for that person because they do things different in their tribe, let's say. Then how do we try to do that? I think it is incumbent upon us to try to see if we can identify an outside community organization or a mentor or an alum or something to help that individual become successful. And it might take more effort, I agree, but I think that is not unreasonable, which is the same thing. We have seen this in some of the African American communities where people do not want to attend AA meetings because I'm talking about Christians who are religious organizations that's why we have secular AA type meetings where they don't have to say they agree with a higher power, let's say. I think that's the language that they use, and they say, well, I won't subscribe to a higher power because my religion forbids that. So if you go to a born again or some kind of Christian-based treatment program, or what they call what's the word? I can't think of it. But there are Christian-based AA type meetings that you can find, or there are there's secular groups that also, I think it's called Recovery. One of them is Recovery. Well, I know people out there listening. Yes. I know there are people on my call that know the more than I do. I can't think of the name. But anyway, what's the name that you called? What did you just say, Michael?
Celebrate Recovery.
Yeah, there's another one, Recovery something. One is an online like AA meeting. I have some stats that I threw up regarding very often our clients are ordered to get work, just go get a job, and if you don't get a job, we don't think you're trying hard enough. But some of the statistics, now these stats are new, but they're actually, there's one group from age 16 to 19. There's another slide, I forgot to put it up, but from this slide I can tell you where the African American unemployment rate is like 31.8%, and in some parts of the country it's upwards of 50%, and Hispanics is 20%, 15.8, and the white unemployment was 15.7. And I believe for the next age group, if my recollection was serving correctly, for the 20 to 24-year-old, the numbers were slightly lower in all of those groups. So it was something like maybe 12 and 18 and 24. I think it was something like that. They were slightly lower, but still the African American unemployment rate is much higher than the unemployment rate for white Americans and Hispanics. So given these statistics and having a prior record, this kind of underscores the challenges that people have not being able to get employment, and then needing to get employment is a requirement of the program, and not doing that then makes it very difficult for people to be viewed as trying not really trying too hard to work in, stay in recovery and or complete the program. The other collateral consequences, I just want to list a few, which you all are aware of: prior records, not having a license, not having a vehicle, unable to afford child care, and the list goes on. So that was our first our issue, but most of it was, yes.
Oh, Yvonne, sorry, we just have one question about the stats while you're on this slide. Marty has asked, do unemployment stats here account for people in prison who are also not employed, so the numbers are even higher for those disproportionately
I don't think that's a good question, Marty. I don't think that this statistic includes incarceration. So that means then the number actually is like 50% and higher. She's right. If you add that incarcerated population of people, that I think it goes up to 50%, which is, I was trying to be conservative with the 31.8, and if you're young and Black, it's even higher. And it depends on if you go to some other parts of the country, it's even worse. Everybody, not just Black folks, but in certain states, some of the statistics are even really, really high. Okay, so let's, okay, I have a couple of resources here. This is a really, really, really good tip. If you get a chance, I put up the slide and the link is there. It is very, very good. And sometimes we are trying to work with our team and trying to not, as a defender in court, I believe for sometimes people viewed my advocacy as enabling. And I have to say that that may have been how some people viewed it, but I think that when you really break down what you're trying to do, you're not enabling people if you are trying to help certain things happen. So I would say that this is a really, really good tool, and I think that if you take a look at it, it might help you. So I would not be discouraged from not advocating simply because people felt that I was enabling. I don't think I was enabling people. Maybe in the early days I might have been, but certainly not as I became more experienced. I wasn't enabling, but I did have to learn how to advocate for my clients without enabling.
It's funny. That's kind of what we aimed at in our second problem.
That's right. Which we can talk about. I think there's one more resource slide. Oh, okay. That has the same tip on it, and also it's a great article by Doug Marlowe on achieving racial and ethnic fairness in drug courts. And I think that is very helpful. And also the best practice standards that talks a lot about the historically disadvantaged groups. And I must say that I don't care if you live in urban America, in rural America, small town, big town. These issues are prevalent. They are hard to kind of get around because they're not the clear violations, but also these are the things that are keeping people from graduating and making their way out of drug court. Some people would rather just put me in jail and just let me do my 9 months or a year or whatever, because they can't seem to make it past the everyday hurdles that are sometimes disguised as these other impediments that are more culturally driven.
May I ask you a question, Yvonne, before we go too much further? And this one I don't know the answer to, but going back to your first challenging problem, the young African American woman, if you've got somebody like that who what we call in our program is on the slow simmer of noncompliance, you know, they're not boiling over, they're not smelling up the kitchen, it's not goop all over the burners, but there's just a slow simmer of I'm just not really getting it done. I'm going to try to wait out my time, wait those guys out. Do you think sometimes maybe the first question, or as a defense counsel, maybe one of the first questions that you ask yourself is, you know, am I looking at this through, or is my team looking at this person through culturally competent lenses? In other words, is there a cultural issue here that I'm not missing? Do you think that's an important question, and where do you ask it, up front or when the simmer goes on and on?
Yeah, that's why that's exactly why these are challenging, you know, population, that slow simmer. And I do think that we have to be willing to hold up the mirror and look at ourselves to see if we're biased, if the lens that we're looking through is our lens, and so we judge it, and therefore they're never going to really be good enough, or maybe they're not going to achieve enough to be you know, kind of promoted along the way. Maybe they'll never meet those standards that we have for them. Some of our programs have very high standards, and they're just kind of biding time just to go along, to get along. And go ahead.
No, I'm sorry. Finish your.
I don't know. I think that you raised a really good question, but I think we have to. Somebody has to be the person in the room that's willing to say, and I always appreciate other team members. By the way, very often I'm the only person of color at a table, and I'll say that to the crowd. You know, those on the call. And sometimes it's an awkward situation if I'm the only person of color in the room or in a drug court environment, and I ask the question. And by the way, I travel all over the country, so sometimes when I go to places where I'm giving technical assistance, I ask the question. And there's no one there that's asking these questions. And by the way, most of the time people aren't upset about the question. They just go, oh, we hadn't thought about that. And then they're more than willing to think about it and to hold up the mirror and take a look. So I think it's incumbent upon attorneys who are well trained, first of all, to know enough to ask the questions, and then to consider that maybe there's something else going on that is not as obvious as somebody who's just being non-compliant. Whenever you say you're being non-compliant and you're just not motivated, why is that? And what is it that what motivates you may not motivate me. I mean, I know you live out there sometimes on a ranch, right? Don't you, Michael?
Oh yeah.
And I don't know what motivates you to do that.
55 years of inertia.
But I'm just saying, I'm gonna come visit one day. But I can't, you know. So we all have different things that motivate us. But you know, being next to people in tight spaces in New York City just really excites me. And so, but that might not motivate others. So it's a really great question. I don't know that I haven't answered completely.
Well, I think the discussion is the main part, is the most important part, because as you know, as I said in our last webinar, and by the way, you know, I am a prosecutor and I appreciate being with you. I'm actually honored to be with you guys, because I think the defense counsel has the hardest, rivals having the hardest job in drug court, with the probation officer and treatment perhaps being close. But this is one of those things, and I think this is a particularly brilliant hypothetical you came up with here, because you know, you look at this, and if you weren't sophisticated, you look at this and like, well, you know what we need to do? We need to try some unique sanctions and some incentives for her, and that may be true. But I think before you can come up with that, you have to ask yourself about culture and say, well, what is it that's motivating her to non-comply, and what can we do to motivate her to comply, or, with culturally competent bounds, change her, sanction her to maybe change her negative behaviors into positive ones. And it's incumbent upon defense counsel, I think, to as the ultimate arbiter of individual rights, or protector of individual rights, I should say, to hold up the mirror, as you say, to the team and say, hey, wait a minute, we're not looking at this through the right lens. And there often can be aha moments because, like defense counsel, the prosecutor is trying not to violate people's rights, but the individual themselves we don't particularly see. We see systems. And so I think, again, that defense counsel brings a crucial seat at the table in this regard.
And people have to be willing to think outside the box. You mentioned the example with somebody a member of a tribe. And if I don't have anybody in my community, I have to be, say, well, I don't have any Native American people here to talk to. Right. What am I going to do? Well, it might just be calling NADCP or American University or whoever and saying, we need somebody that's familiar with tribal, a tribal issue. We don't have anybody. It doesn't have to be anybody in your town or in your community. You might have to go outside of your community just to get information. But I think the important thing is, and the way you do it, I think, is that rather than wait till we have problems, I think it's most important for people to upfront across the board just ask themselves, let's do a self-assessment. We don't have any issues right now. We can't even, and you would be amazed, unless you've done some, and I've done some of these trainings, you don't even recognize your own bias until you've actually done a little bit of self-assessment. And
I definitely agree with that.
And once you do it, you would be amazed. So I think it's incumbent upon drug court teams, and sometimes we can give it to the prosecutor and let them think it's their idea. I'm only joking. No, but
hey, whatever it takes.
Whatever it takes. Or you know what? But I'm serious. I would call another prosecutor like you if I was having a prosecutor if I'm having a problem with my prosecutor. I would call somebody like you, Loeffler, if I've been on this call, and I would call you up or send you an email privately and say, my prosecutor doesn't get it. Will you call him? And I would say to you, Mike, would you call a prosecutor tomorrow if somebody sent you an email like that?
I would call the devil tomorrow if you told me to. Yes, I would. Of course I would.
So I'm just saying that we have to think outside the box, and I think I really do, honestly, to the group, I want to say that Mike would call, but I'm thinking that you have to kind of reach outside sometimes.
Well, and I just answered a question privately about non-AA, non-higher power, community support groups. Sometimes as defense counsel, I think we have to, as you say, go outside the box. But I think we maybe not on an individual representation level, but as for the team in general and participants in general, talk to Smart Recovery, talk to Celebrate Recovery, talk to some, find the electronic medium where you can do these meetings online. Recruit people to come into your community if so possible, because everybody's trying to spread their word, and if they have non-AA support group, they may want to do one in your town to sample. I mean, it's the things that you have to do as defense counsel are legion, and that's one of the things I think is so challenging about it. Prosecutor, I don't think is nearly as challenging because we've got plenty to do, but it's all kind of within boundaries. There's something that you might want to do that may not bear fruit for months or for anybody for a while, but it definitely needs to be there.
That's right. Right. Good. Okay, we're going to move on to the next case. Do you want me to go over the background, or you want to do it, Mike?
Oh, I'll do that. Let me give you a rest, if you don't mind, and then I want you to jump
go right ahead.
And again, let me say I didn't get to up front, but I appreciate the ability to be on this webinar. Again, I told you I'm honored, and I am. This is tough. We're going to shift gears a little bit here, and we're going shift purely from culture, although as we just talked about, that you can really never shift from it totally, or you shouldn't. And we're going to look at we're going to look at some ethics, and we're going to look at some confidentiality. And I think this is a huge challenge for defense counsel. It's something that I don't have to deal with, quite frankly, in the prosecutor's office by and large. And we'll go through this, and this is an actual case from a court that I'm aware of, and this actually happened. The names have been changed, of course, to protect the innocent. Rachel's contract indigent defense counsel, meaning like many states out there, you know, there is no state public defender office, as Yvonne used to run in a big state, New Jersey. This contract indigent defense counsel takes, you know, clients as they're assigned by the court. And she's had several cases in this fictitious drug court that we have. She has a client, Jennifer, whom she pled into drug court on a long suspended sentence. You all can read this. I'll just paraphrase. But unlike the slow simmer of noncompliance that we talked about in case one, this person has a pretty good noncompliance. She has a pretty good boil going. She's a bright, intelligent woman, but she's got some sexual trauma in her past. She became addicted young. She's high risk, high need, obviously. During her most recent jail stint, she actually went through withdrawal in jail. Jennifer connected with her, or excuse me, Rachel connected with Jennifer, and that connection will be important as we go on. Next slide, please. She's had several non-compliant events, as we said. They're started off with low-level failure to fully engage in treatment. That might be one of those questions you might talk about culture. She's not been in safe, sober housing. She's got a medical marijuana prescription, which is legal, but not allowed in this court. She's had a couple of positive UAs for opioids, and she's had some minor sanctions that are listed there. The drug court team is considering moving her up to a higher level of care, and that would be determined by the treatment people, of course, and more strenuous sanctions to do something to change her behavior. The prosecutor is actually wondering out loud that she wasn't headed for termination just because of her continual noncompliance. During the same time frame, Rachel becomes pregnant by another participant, which is a no-no in this program and many. And Jennifer instructed Rachel to maintain her confidence in this regard, and that is the most important sentence that we've read so far. Next slide. So Rachel refers Jennifer to the county health department for prenatal check, and to a local doctor. She's been successful in the past treating clients with Vivitrol, which is time-released naltrexone. Jennifer complied, but instead she got a Suboxone prescription. Jennifer requested confidentiality of this script as well because she wanted to beat this thing herself. This went on for several weeks, non-compliance, skipping court. When she was about to get a sanction and for being positive again, this time for the Suboxone and her legally prescribed weed. This is the next important sentence that we talked about in this on the slides, is that Jennifer promised Rachel she would get clean and stay clean if Rachel should buy her some time, and Rachel complies. Asked for a due process hearing on the positive for Suboxone and weed. And in the interim, a female probation officer discovers, for whatever reason, that Jennifer is in fact pregnant, and she discloses that, but not the script for Suboxone. At the due process hearing that finally comes around, the court declined to sanction her, but followed treatment's recommendation to move her to a higher level of care at Patient Women and Children's Facility, where she would stay until the end of her pregnancy. For some reason, they didn't inform anyone of the Suboxone use. Jennifer had a baby boy. He was healthy, but positive for opioids due to the RX in the meconium. The team learned of the quote-unquote dirty baby. I put that up there. Don't like that language, but that's what it's referred to. This is a program violation as well. And the judge decided he was was terminating Jennifer because of this serious non-compliant event and the totality of her non-compliance. Again, he knows nothing about the Suboxone at this point. Rachel got another due process hearing set. At this due process hearing for termination, the Suboxone was disclosed. Doesn't matter how. It was probably in open court during testimony. A retest was conducted in meconium and determined that the baby was positive for Suboxone, rather than something like heroin or illegally obtained opioid, and that the child had suffered some withdrawal symptoms while at the hospital. The court, after another staffing, this time imposes a number of serious restrictive measures, including house arrest electronically, increased testing, treatment, and the like, that really finally more or less gets a hold of Jennifer's problem. I have to put that in there. Although it does, Rachel tells Jennifer tells Rachel she's going to commit suicide if she can't get out of the house arrest. Rachel didn't believe Jennifer, and that may have been realistic, and she informed no one of the suicide threat. Shortly thereafter, she files a motion to withdraw as Jennifer's counsel. All right. Now, this is kind of important, folks. I want you to try to use the chat function here. We can go through and talk about this. Yvonne and I can tease this 6 ways from Sunday, as we say in Oklahoma. But I would rather for other people to weigh in on this and either make comments or ask questions. Otherwise, it's going to be a pretty boring, dry lecture on a hypothetical from what looks like a PR class or law school. So, our questions for discussion are this: did Rachel do anything that was clearly unethical? Did she do anything that was arguably unethical? What errors, not necessarily professional responsibility errors, do you think that she made? How would you have handled this differently, maybe is a better way to say it. And just assume the facts in evidence right now. There's no other facts. Where would you have intervened? What would you have done? What would you have counseled? What would you have done differently? What would you have done in addition? Let's talk about that. And I'm going to bandy that out, and let's just talk about some of the issues that are out there. Can we go back to the first title slide, please? I think 3 slides prior.
I'm waiting to hear what some folks out there who are on this call want. I want to know what they think.
I'm playing for some time. I'm waiting to see.
Yeah, we kind of know what we were going to say, but I really wonder from the participants who are on this call, as defense, for those of you, because I know there are a few people that are not defense counsel, but for the defense counsel on the call, what do you do? What do what do we do? What should we be doing when our client tells us something, they don't want us to share it, and we know it's not really helpful to their treatment, certainly not helpful for their recovery, but our clients have confidentiality, and I should distinguish that from a privileged communication. Had she gotten into a car wreck and she was high on drugs and illegal drugs and she had a new charge pending, well, that's privileged communication. I don't have to share that with anybody. I can't talk to anybody about it. And if she comes and tells me I got arrested last night, I had drugs in the car, that's completely privileged. Nobody can touch me. No judge can ask me about it. But that's very different from when your client tells you, or it's maybe your client's mother or boyfriend tells you that, boy, my client Jennifer, who's the client here? Jennifer is my client, and Jennifer comes to me and says, Mrs. Segars, I'm pregnant by another participant. Now that's all kinds of wrong for reasons, but technically, if she has shared with me in confidence, unless I've been given her consent, I have to honor her confidence, and that runs counter to what we are doing in drug court, what you want to do. Now, what would I do? I would sit down with my client. I might chat with her.
Well, let me stop you, Yvonne. Let me stop you right there. Let's just talk about that first question before we go on to what we would have done. And we got a question here that I'll get to in just a second, but. Has she done anything clearly unethical? And one of our comments here says, not clearly unethical to keep the Suboxone, et cetera, a secret, arguably so if the drug use while pregnant was a clear threat to the fetus, which is a good comment I hadn't thought of. especially if the law declares that it is a child at some point in the pregnancy. Yeah, and that's an unknown that you don't have there. Again, assume only the facts in evidence. Suicide threat is always a hard call, ethics versus moral. Yeah, but let's go back to one of our study questions, and that is, did she do anything clearly unethical?
Well, from the beginning, the defense counsel not sharing what her client has told her, which is she's pregnant. If that is something that she does not want to share with the group, that's a confidential communication, and that is not unethical to keep that private unless she has her client's consent. That's my understanding. If there are those who may not agree, I don't know.
Well, states can differ, but my take on it was, and I'm of course asking you questions that I think I know the answer to, like, oh, good trial lawyers, but I don't see anything that she's done that's clearly unethical. I think she's maintained her confidence. It's problematic. It's problematic for Jennifer. It's not the smart thing to do. You know, it's not the decision that I would make. But and you talk about that counterintuitive thing again. Is yeah, but you know, the professional responsibility rule is you keep your client's confidences, right? Yes,
you do, unless they've given you consent to share them. Sometimes we gain confidential information by people outside of, other than the client. I think that kind of puts it in a different category. But if it's because of your relationship with the client that someone has shared confidential information, then you have to seek the client's consent in order to share that confidential information. Now, if the client has spoken to other parties, other third parties, there's no confidentiality.
Right.
I mean, it just evaporates.
Well, and at the point in this hypothetical, that's when she discloses to the PO or whoever was doing the drug test that she was in
but
fact
then again,
pregnant.
the PO in this fact pattern, and which is what I actually, I guess, secretly sometimes, you just want, if everybody else kind of does their job, things do come out in the wash, right? So if clients are being randomly treated, screened for, toxicology and the UAs, then if they're using, eventually that's all going to surface. Even if my client tells me that they're using, and I remember early on in drug court, people would be so upset when they would say, gee, if your client told you that she got high last night, do you tell? Of course I don't tell. I do not tell. That is confidential. Now, I can't, unless my client allows me to disclose it, I can't. So can I encourage my client to go forward and be honest? Yes. Can I, hope that, do we want her number? Listen, on the other side of the coin is that you want your clients to make it out of the program, and hopefully they stay alive and they don't overdose and they don't, really harm themselves any further. So that's when the program itself has to come forward, which is having, random and frequent urine monitoring and drug testing. That's what the program needs to do. But that's not my job to tell them when people are dirty. But I think somebody has also mentioned, which I agree with, that if the woman is pregnant and there's some laws regarding drug use while you're pregnant, and you can, of course, create a threat to the fetus, then that's one of those, that slippery slope.
If she's committing an ongoing crime, that becomes, and I didn't even think of that. That's a brilliant, because we don't have that law in my state. But that was a brilliant comment by the questioner that that obviously is an exception as well. So there is an arguably unethical thing right there, or at least problematic, that I had not even talked about. Let me go to kind of from a 10,000-foot view to a 40,000-foot view, and throw a rhetorical question that I'll answer here is, so what has Jennifer accomplished by looking at this? If you look at this whole fact pattern, Jennifer has succeeded in being able to continue to use from basically the time she was arrested and went into drug court until everything finally came clean at her termination hearing. And then she gets very restrictive consequences, which may at least temporarily get a hold of the problem. Those restrictive, if you're a team member, and this is a problem for defense counsel, and this is where I feel for you all, if you're on that team, you think, well, you know, Yvonne, we should have been able to deploy these restrictive consequences on Jennifer a lot earlier, saved the baby the withdrawal, kept her clean, et cetera, et cetera, et cetera, and now we're 9 months plus later, and she's been using the whole time. Thanks, Yvonne. And I'm being facetious there, of
course.
That's
right, but it's true, right.
You know, and I suppose it's true, but it's really hard, I think, if you're defense counsel to, and I don't think anybody tells you this when you get that assignment going into drug court, where, you know, it's kind of easy to keep your confidences pre-trial, right?
Yeah.
Because here's what I did, here's what I didn't do, here's what I know, Ms. Segars, Mr. Loeffler, you're defending me. I don't want anybody to know this, but, you know, this person knows, this person's a witness as well, and et cetera. It's easy to keep those, and we're used to that. But where you have continual contact with the client after post-trial, basically, post-plea, and you're still learning confidential information, and they're still requiring you to keep it quiet, which doesn't matter when you learn it. Boy, that's a sticky wicket for me. I tell you, I mean, I understand you can do it. I would do it, but you've got to be cognizant of it. Just because you're on, and correct me if I'm wrong, Yvonne, this is the way I'd look at it as defense counsel. Just because I'm on that drug court team and we share intelligence doesn't mean that I can violate my my responsibility of it. And yeah.
Right. And that's where it comes into making sure that your team is well educated about my role as defense counsel, which is unique to any other person. Nobody else on the team has the same obligation or duty to the client like the defense counsel, which is also underscores the importance of having one-on-one representation. Now, if you were the, in some courts they use this this defense representative formula where the person basically represents the team, which I think is really not a good approach. I don't think it should be used at all, but I know that some teams are using this method of representing counsel. That person who represents the team has no duty or obligation, I don't think legally, to the individual. It is to the team. So they're not, I don't think they have this, I don't think that they're trying to create the same ethical line there, which is what you do want. I would never, want to have someone in the court that doesn't have proper counsel, because these are the kinds of issues that start out as the little foxes that kind of grow up into big problems down the road. Whether it is I am involved with another participant, which everybody knows is a rule of no fraternization amongst treatment participants. That's just like old school rule, but it happens all the time. And people get thrown out of drug courts left and right because of violating the no fraternization rule. And that's not unusual. But in this case, if somebody gets pregnant, then what? So I just think it's a very difficult issue, but it's important that, one, defense counsel know that they do have ethical responsibilities, that they're not required to violate those ethical rules. They need to know what they are. They need to know they need to know what's confidential communications, which is if you just think of it, it's a big, big room when we talk about confidential communications versus privileged communications, which are just really related to anything that you're seeking legal advice for, or a new charge or something of that sort. Those are what we refer to as the privileged communications, which are much more narrow and more well-defined. It is the confidential communications that we come in contact with that tend to be more problematic. And even more so when we represent more than many of the attorneys who are in treatment court represent half the other people in the treatment program, especially if you're a staff public defender or your staff counsel in the local public defender office. You might represent, you should, in my county, there's only 2 public defenders and they all represent everyone, but they have individual representation for each person. So they represent everyone, but there's often, you know, conflicts with people, or somebody tells you something about somebody else, and now you have a conflicted situation, which sometimes you have to understand. If there's a conflict that arises, what do you need to do to get out of it? And sometimes you have to extricate yourself by, you know, assigning another counsel. But in this case, we talk about the conflict here at the end, where the client, you know, threatens suicide. Quite frankly, if you think somebody is really going to hurt themselves or others, I think that you have a duty to disclose in that situation. And,
well, and I threw that in there for a very personal reason, and that is, I don't have the statistics, but I can tell you to a man, or not to a man, but to a person, how many people have committed suicide in my program from the last 20 years. And I wish. And I'm not blaming any defense counsel. Don't get me wrong. That's what I'm saying. But I'm wishing that someone would, you know, at some point, if it were at all possible, be it a family member or a defense lawyer or a prosecutor overhearing something, or a probation officer, to understand that there's a lot of depression, there's a lot of mental disorders that go on here, and suicidal ideations are not infrequent. Yeah, and suicides are not infrequent. And I just, you know, we do all these things, and we look at this and say, well, this is our recidivism rate, and we've had this many clean babies, and this many people have got GEDs, as you've talked about earlier, and done all these wonderful things, but 7 people have committed suicide. You know, I mean, you start to weigh that and go, well, you know, we can't count the ones we've saved, but we can sure count the ones we've lost. And I just want to, you know, I tell people in training a lot when I do sanctions and sentence presentations that, you know, as lawyers, as judges, not just restricted to defense counsel, we often want to say things. Well, let's try her in inpatient treatment, or let's send her to IOP, or let's do this or do that. You know, we're not necessarily, unless we stayed at the Holiday Inn Express last night, we're not qualified to make this kind of thing. We can enforce them if treatment comes to us, but we're not clinicians. We can't take people off of drugs or put them off of drugs, and neither can we do that. I think of someone, and you may want to jump all over me on this, Yvonne, because I know you're not shy about doing that. But you know, somebody even out loud ponders suicide. I'm gonna overreact. Maybe not overreact, but I'm going to act like it's serious, and it may end up being an overreaction. And this may have been BS that Jennifer was feeding Rachel here, but and she may have been manipulating her because they had a connection. But boy, I would sure hate to think for my mental health as defense counsel, if I was Rachel, what would happen if Jennifer followed through. You know, I would have some PTSD at that point, I would think, and you know, being a defense lawyer, being a lawyer in general is hard enough without not doing everything you can in that regard.
I agree. I agree. I agree with everything you said. I think it's a very tough, slippery slope. We already know we had a webinar. Our first webinar was on mental health. Disease and cognitive disabilities, and just speaking of women, because we have a female fact pattern here, 74, I think what the number was 74%. 74% of all women in jail and prison with underlying on substance abuse charges, I believe that's what it was. We have that slide somewhere. 74% are also have co-occurring mental health disease or disorder. So it's a statistics that's glaring. This is not unusual. We should expect that statistic, 74% of our female population may very well have an underlying mental health disease or disorder. With that in mind, we can't take it lightly. And when people threaten things like suicide, we should take it very seriously. The question then goes, what do we do? and do we have a duty to disclose? And I think that you can only really, I always say, if you don't know, counsel with others, and
right.
don't make the decision by yourself.
Well, and I'm so glad you said that too, because when I was in the dark days when I was in private practice, if I had an ethical issue, and I know our state bar counsel counsels us on this, is to reach out to another lawyer, because even if you make a mistake, you've identified the problem, you've reached out, and you know, it mitigates your mistakes, and a lot of times will avoid your mistakes. Obviously, reach out to the people that you know that have been there. You know, I get calls not because I'm wise, because I'm just like Yoda. I've just been in the same spot for many years, and people say, well, what about X? And I get those. I probably get more of those from public defenders than I get from prosecutors, because again, I think that the ethical burdens on defense lawyers are a little bit more acute. But you know, reach out to other people that you respect intellectually or professionally. They may have some wise counsel, and I think that maybe that might have been something that would have helped Jennifer here probably earlier than the suicide threat. Is that, hey, you know what you're doing is, now this is arguable, but honestly, you may be, you know, encouraging, enabling this woman. Look at the people who are in danger here. You know, this is all going to come out in the wash, as Yvonne said, at some point, regardless of how it comes out. You can't wash it out, but it's going to come out. Mm-hmm. You know, you need to strenuously counsel her, do this, you know, jump up and down and stamp your feet if you have to on these people. We can all manage clients. Everybody knows that. If you don't know that, you know, I manage victims a lot and get them to do what I think is the right thing to do in the long run. And lawyers do the same thing with their clients. I did when I was in private practice. I did when I was a defense lawyer. You know, you can move them to where they want to be. That's the counselor part of being a lawyer, I think. And there are lawyers that don't like to substitute their judgment for others. But I think you have to give your best advice. I think that's one of the glowing points of being a lawyer and being a lawyer for a long time, is that you can see how, you know, you can see the chess game as it going way before you get to the chess checkmate. You know how it's going to turn out.
And I also think with a lot of our clients, if we create for them, many times our clients paint themselves into a corner. If we can give them a way out, that is by offering an opportunity for them to speak to someone that they can help make a decision about an issue. If she paints herself into a corner by getting pregnant by a participant, she doesn't want out of, I'm not sure if she wants out of, this person wanted out of the program or not, but maybe she was doing all that she could to get out of the program. You know, let me just have a baby by the participant. Surely they'll throw me out now, right? Surely they'll throw me out. Surely. And still, people in drug court, we tend to keep really trying to work hard to keep people engaged in treatment. But sometimes we also have to help people who have painted themselves into a corner have an avenue out. We can sometimes guide them to that avenue as a way of them figuring out what to do. But of course, you can only do that when they give you consent to do it in lots of cases. So I always argue, you know, try to create an avenue for them to extricate themselves from situations, offer that to them as a way to get, if they can kind of see their way out of a particular situation, at the same time not being unrealistic about what the expectations are or the consequences are of what will happen. So long as people are clear of what consequences are, they kind of know where they're headed, then they can maybe see their ways out. Sometimes the consequences, you and I both know that there's no real way out, that the ultimate, you know, ending here might be to state prison. And at that point, I don't think that, certainly as defense counsel, I can't help them in any situation other, because I know that might be the outcome. Why would I have to do nothing more than protect their confidences and their information and any other obligation, ethical duty I have to them to protect, and that's what I should do. But if we can create a situation where there's a way for them to extricate themselves and we can offer an avenue out that is consistent with our obligation and our duties without violating our ethical responsibilities, we should. But sometimes we can craft that for them where they can't see it for themselves. We can help craft it and can help kind of lead them out of the forest.
Good.
That's what I would say. I think that the one other issue that we didn't talk about was that, Jennifer filed a motion to withdraw. In my state, we never get those. They never let us out of a case. We're stuck. But if your judge would have granted the motion to withdraw, it's very hard to get let out of a case like that if you're that far in. But I can see it happening.
I had that as when I had this person when I had Rachel as privately retained, and that might have been a good thing for her to do, well before this. It's something had she been privately retained and not client forced upon her by appointment.
Right. I don't know if we have anything else. Do we have any more responses? I don't see any.
I think at this point we don't have any other comments or questions.
Okay.
So I would just like to thank both of you so much for all of your insight and the time that you've given to this webinar, and for everybody for staying on. I think almost every single person stayed on for the entire time, which is really great. So thank you all so much for your attendance and for your participation. If you have more questions.
I want to just say one thing before we hang up. Are we?
Sure.
If those of you who are on the call, other attendees, what we really want to do is to create as many, useful webinars for your purposes, for your use. And we really would like you to stay and give us as much feedback, positive, negative, what we can do better, what you'd like us to do, what we haven't done, what you really are looking for, so that we can try to craft webinars that are useful to you and your time. So please,
let me echo that.
Feel free.
I absolutely echo that and agree with that. That it is nice to have this forum, but it needs to be. We need to make sure that it is in fact cogent or timely for everybody, and that we hit the right issues that affect the most people, because we're dealing with people's lives here.
And we know how much time. We know your time is valuable, so we really want to thank you for taking that hour to spend with us.
Yes, kudos for you for doing that.
Thank you. Thank you.
Well, thank you all so much. And again, please stay and fill out the evaluation on the survey at the end. And please feel free to reach out to us here at the Justice Programs Office at American University, and we will address any other additional questions or comments you may have, and also reach out to us if there's anything you're struggling with and if we can be of any assistance to you.
And if anybody comes to the drug court conference, see you out in Anaheim.
Yes. Please look
we'll be there. We'll all be there.
Safe travels.
Okay, you too. Bye.